her grandkids, to be a part of birthdays, holidays, and everyday lives. I was only beginning to see her really step into that role of grandma. She loved every second of it. We were finally getting to enjoy life with her again, and then I woke up one morning and she was just gone. The shock of losing her so suddenly and in the manner that it happened has left a hole in my heart that will never heal. She must have been so afraid, probably thinking of me and my boys. I know I would be thinking of my children. It is hard for me to understand how someone can be so careless with something they claim to love so much. Her death was completely preventable. There is no reason that she shouldn't be here right now. And the choices that have caused it have left a lasting impact that no sentence can erase. We feel this loss every single day, and our family will never be the same. I am asking the court to hold Mr. Thone fully accountable. I support the PSI recommendation of 16 to 18 years, and I believe a strong sentence is necessary to reflect the seriousness of taking a life.
This is what makes victim impact statements so powerful. It's not just about death, it's about timing. A woman rebuilding her life, reconnecting with family, stepping into grandmotherhood, and then it's all erased. Judges carry these moments into sentencing.
Nothing will bring her back, but I hope this sentence sends the message that reckless decisions have devastating consequences and that justice must be served. Thank you for your time, Your Honor.
Thank you, Ms. Kopinsky. I am now going to ask Jessica Glosky, and spelled Glosky. Is that correct, Ms. Glosky?
Yes.
I am now going to ask you to present your statement to the court.
First off, to Rick, your careless actions, the drinking, the reckless behavior, has resulted in a major loss for our family. You have taken Jennifer away from us in a horrible, unspeakable way. I wish she would have left when she had the chance. 2 little boys are now without their grandma, and to have told them that she's never coming back was the most heartbreaking. One would think after a very similar...
Those words matter legally. Preventable deaths trigger harsher sentences because they speak directly to recklessness, not fate. The law distinguishes between tragedy and choice, and this case is being framed as the latter.
UTV accident 4 months earlier, you would have had a wake-up call to stop drinking. You almost killed her then. When you love and care for someone, you do all you can to protect them. With your actions in just a couple years, you have proven you never really cared. I believe you should be held accountable for your actions to the fullest. You need to take responsibility for what you have done. Judge, I ask you to please give the maximum sentence. I do not feel Rick should get out with his impulsive behavior. He'll just continue his recklessness. Please do not let him risk someone else's life. He has proven that he cannot be trusted to repeat again. Thank you.
Ms. Glosky, what is your relationship with the victim?
Her niece.
All right. Okay, thank you so much. All right, Ms. Bauer, may we have the other individual, please? And they can come and have a seat over there at the black desk. Please either state your name for the record, or you can state your initials. And I didn't want to interrupt Samantha or Jessica during their statements, but if you're going to read something, please read it slowly, so that not only can we all understand it, but so the reporter can.
Okay, my name is Jennifer Kopinsky. I am Jennifer's sister.
And I understand that this is very emotional, so please, if you need to stop and take a breath and to calm yourself, you may do so. We are not in any rush here.
This is where emotion intersects with evidence. The court isn't just hearing grief, it's hearing about repetition. Prior incidents turn sympathy into scrutiny. At this point, the judge isn't asking what happened. But why didn't this stop?
Today, this is our main focus. And there are Kleenexes right there. But again, take your time. Miss Bauer can read it for you if you would like her to do that.
I can't. I mean, it's pretty similar, but sorry, I just can't.
There's no apology necessary. This is very emotional.
You have to be the phone and all this. Rick, because of your reckless behavior in August 2024, you took my sister Jennifer from us. You took Samantha's mother, Max, and Alistair's grandmother. You took an aunt, cousin, and a special friend. So many. It wasn't the first time you caused harm to Jennifer. The accident in May left Jennifer with serious injuries. You would have thought you would have had straightened up, stopped the recklessness behavior, but you didn't. Because of this, you should spend the rest of the days locked up to think about what you have done to Jennifer and her family. I miss Jennifer every day. Because of you, I will never see her again. Judge, please sentence Rick to the maximum sentence. He has been reckless with his life. He shouldn't have the ability to destroy another family. Sincerely, again.
Thank you so much. All right, we may go return to the gallery. Mr. Schmidt, I'm now going to turn to you for the state's argument and recommendation.
My recommendation is going to be a 17.5-year recommendation broken up into 7.5 years initial confinement, 10 years extended supervision. So that's a little bit lower than the PSI initial confinement, a little bit longer on the extended supervision. The general purposes I think the court should weigh heavily on this one would be incapacitation and protection of the public, as well as general deterrence and punishment. My recommendation is necessary to not appreciate the gravity of the offense or the loss suffered by the community and the family of the. There's really only one place I can possibly start this argument, and that's with this. Richard Thone killed Jennifer Kopinsky. She was his fiancée. They had been together for a substantial period of time. From review of this case, as well as my review of other cases, including Barron and Douglas, they obviously loved each other deeply. His remorse at what he's done is genuine. That he has obviously both inflicted and suffered a great loss because of his actions. I don't think anyone could legitimately disagree with that. I state those things to make the general point, not just with Mr. Thone, not just with the family. In this case, great loss has occurred, and as a result, this is a high severity offense. This is a high gravity offense, and prison is necessary. That's why the legislature made this offense have a statutory minimum of 5 years initial confinement, which, to compare, 5 years is higher than the statutory minimum of OWI 10, 20, or 50. The legislature thinks when someone dies as a result of an OWI, it is more serious than the most serious OWI offense. So he recommends 9 to 10 in, 7 to 8 out. Mine's a bit different. So I'm going to describe what I think are the aggravating and the mitigating factors. The loss to Mr. Thone is the main mitigating factor. Okay, there's another one I'll allude to in a minute. This is an offense that involves alcohol, driving, and harm done to Jennifer Kopinsky. What's disturbing about that is when you look at Mr. Thone's history, you see a pattern of those three things, not just in terms of physical injury, but other impacts as well, other negative influence. One, that this death was both eminently predictable and eminently preventable by Mr. Thone. Second thing I want to point out is that history demonstrates this. It demonstrates Mr. Thone's lack of ability to change his behavior to prevent this predictable death, despite his professed love for the victim and his professed remorse for her death. He seemed to drag her down with him in his own apparent despair about his own health conditions. Part of that is obvious from the PSI. The agent hit on it, and I've talked about it at past hearings in this case. 4 months before this event happened, a similar event happened in Barron County. Richard Thone rolled a black Yamaha UTV or ATV in Barron County and PT'd there above 0.08. Both he and Jennifer were injured. That is, she was with him at that one as well. What we didn't know prior to the PSI is that when Mr. Thone was interviewed by DOC, because he was still on probation at the time that happened in Vaughan, he himself had recognized that they were lucky to be alive, and he claimed he would never drink again. Claimed that he had been impacted by that case, potential threat to their lives by the danger of this ATV rollover. He had been consuming alcohol, and he wouldn't drink again. 4 months later, he did drink again, he did drive again, Ms. Kopinsky is with him again.
This is the prosecutor's thesis in one sentence. Predictable means foreseeable. Preventable means avoidable. Together, they could justify prison, not probation. This framing directly supports incapacitation and public protection as sentencing priorities.
Driving really the same type of vehicle, a new black Yamaha ATV, bought a similar one to the one he had owned previously. And it crashed, and Ms. Kopinsky was not lucky this time. Mr. Thone agrees in the PSI that he was intoxicated, but he also seems to complain that there was also something wrong with the trail in some manner. So he is accepting responsibility, which is a positive. It is disheartening that Mr. Thone would do the exact same thing 4 months later. That nearly dying and nearly killing Ms. Kopinsky 4 months earlier did not actually change his behavior. I think it would be helpful for the court to have some more information about that DC obstruction that occurred in Douglas County, as mentioned in the past history in the PSI. According to the police reports in that past Douglas case, a Douglas County deputy had a call that people were alleging that Mr. Thone and Ms. Kopinsky were being disorderly at a tavern. On the way there, he happened to see their vehicle passing. He shined a spotlight on the driver's side and affirmatively saw a male driver and an unknown passenger. He hung a U-turn, pulled the vehicle over. He could visually see as he was approaching, he could see the driver moving into the back seat and the passenger moving into the driver's seat. When he approached the vehicle, it was Ms. Kopinsky who was sitting in the driver's seat, Mr. Thone sitting in the back. They claimed that she was driving the whole time and that Mr. Thone hadn't drank at all, another thing that was proven false later with subsequent tests. As a result, Mr. Thone was convicted of that obstruction for lying about that. And in fact, Ms. Kopinsky was also convicted of obstruction in Douglas 22 FO951. Under Mr. Thone's presence and influence, I can't say direction because I don't know that. Under his influence, she was willing to lie to shield him from drinking and driving where she was the passenger. Mr. Thone mentions in the PSI, though it's a mitigating factor, and I suspect the defense is going to argue this one too. That is the fact that Mr. Thone has a disease called Huntington's disease. Huntington's disease is a horrific genetic disorder. It causes profoundly negative, degenerative, impactful symptoms that only worsen and worsen until the person. It's really terrible. I feel truly sorry for anyone who has it, including Mr. Thone. Right off the bat, with the severity of symptoms Mr. Thone describes in the PSI, there's a real question of why is he driving at all? Not in terms of is he legally allowed to, what could you do? I mean the question of what should you do. The way he describes how it impacts him in all the myriad ways, the way that it's mentioned that the doctors have questioned it in the past, it certainly doesn't seem safe for Mr. Thone to be driving at all. His condition is as he describes it. And yet he continues to do it. I think that's further exacerbated and becomes an aggravating factor when we consider the fact that the PSI clearly contemplates it's not good to be consuming alcohol if you have Huntington's and you're taking the appropriate medications for Huntington's. In the PSI, it seems Mr. Thone is remarkably capable of speaking about the effect of his Huntington's, the symptoms of the Huntington's. He's a very good historian of that. Yet he doesn't seem capable of modifying his life, his behavior, his actions, in light of what he clearly knows about the symptoms and the impact of Huntington's on him. His sister's theory, according to the PSI, seemed to be that she believed that he's come to some sort of place in life where rather than this being this drinking and driving behavior, this repetitive behavior, started late in Mr. Thone's life, rather than being a result of cognitive problem from Huntington's, that it's more of a, pardon my language, like a what the hell attitude, where I have this horrible disease, it's going to get worse, I'm going to die, who cares? Why not? Why live for tomorrow? Why not live for today? You only live once kind of attitude. The way he describes, in particular, the memory effect of his Huntington's and the PSI leads to the obvious conclusion that it seems unlikely that he would be a person, be a candidate for believing he will be specifically deterred by impacts of his own conduct, or that rehabilitation will be easy or fast or successful at all. 7.5 years initial confinement is necessary to incapacitate him, to protect the community, to generally deter people like Mr. Thone, and to have higher odds of specifically deterring him, rehabilitating him in a controlled setting. 10 years extended supervision will likely be enough to make sure DOC can watch him carefully, possibly with his diagnosis, the rest of his life. It is now more predictable than ever that Mr. Thone could pose a serious risk. He is telling you himself in the PSI that his disease makes it unlikely that he is going to remember details that would normally have a specific deterrent effect. He's demonstrated a consistent pattern of undesirable behavior that has not been shaken by terrible consequences to him, to people close to him, even prior to this incident. This sentence is how you prevent it. 5 years, the statutory minimum, would be too little for a case like this where there are aggravating factors.
Thank you, Mr. Schmidt. Argument, Mr. Nelson?
Thank you, Your Honor. I want to address a couple of things that the state had mentioned, specifically with respect to the Douglas County offense from 2022. I actually represented Mr. Thone on that matter, and so I can maybe shed a little bit of light into what was going on there. He was initially charged with an OWI in that case. That was later dismissed due to evidentiary concerns. I don't think it had to do so much with whether the state was going to believe or a jury would have believed Ms. Kopinsky was the driver. I don't think that was the issue. The issue that actually came up in that case was with the arresting officer, the sheriff's deputy. I think there had been some misconduct that had been occurring with that particular deputy, and that deputy no longer works for Douglas County anymore. So he had been dismissed. And that was a major. I wish I could take credit for excellent lawyering in that case and getting the case dismissed, but that's not really what happened, Judge. So there were issues there with credibility of that officer and the ability to call that officer as witness. And that's what resulted in that. So, as a result, Mr. Thone certainly claimed innocence in that case, and Ms. Kopinsky backed him in that regard. There's an official diagnosis of Huntington's with Mr. Thone in 2020, and then there was a genetic confirmation of that in 2021. But there's also mention in the PSI that if his friends or family or what, they had noticed what they regarded as symptoms probably for a couple of years before that. So I think realistically, if we're looking at a time frame for Mr. Thone's Huntington's issues, we're probably talking about an onset of around 2018. Looking at his prior history, Your Honor, there was a 2016 first offense OWI. Unfortunately in Wisconsin, it's not uncommon to have a first offense OWI. I'm not an expert in Huntington's disease, but I think it is a little unusual for a person, Mr. Thone at this point is 56 years old, to have gone 45 years plus of life without seeming to have a problem with alcohol, without seeming to have a problem with driving or any of these issues, these recklessness types of issues. And then right around the time this Huntington's disease emerges, he starts to have this very impulsive type of behavior. And I just, it just suggests to me, and again, like I said, I'm not an expert in Huntington's, but the record, the timeline just suggests to me that there's something that's affecting him cognitively, his impulsive behavior. I wasn't, best friends with Jennifer Kopinsky or anything. I don't want to make it seem like that, but I certainly did. There was never a situation, Your Honor, I dealt with Mr. Thone and did deal with Ms. Kopinsky. They were together constantly. And Ms. Kopinsky, in many ways, was Mr. Thone's biggest offender, and had a hard time communicating. And Ms. Kopinsky would jump in, and she would be the one that stuck up for him and advocated for him. I think that he relied on her a lot, and I don't think there's kind of been a suggestion that Mr. Thone doesn't care about what's happened, or that his feelings for her were not genuine or something. To me, that's crazy. That's a crazy assertion. I don't think there's any basis to conclude that. I think that they were two peas in a pod. When I had heard about this case and the fact that she had lost her life, it was very sad to hear that. I liked Ms. Kopinsky. She was a nice lady. And it's very heartbreaking to hear that this had happened. And for what it's worth, Mr. Thone has never indicated anything other than that he is absolutely devastated by what he's done. The real reason that you don't drink and drive is this case. This is the real reason you don't drink and drive, because Mr. Thone, who doesn't remember anything, he was also injured in this accident, and I think was found more or less comatose or moderately unresponsive when the EMS workers came to the scene. But he received a good knock on the head. But at any rate, Mr. Thone more or less came to or woke up in the hospital and had to be told that all of this happened. And he's had to process that now he's responsible for this. And this is something that he wakes up every day and has to think about the loss of Ms. Kopinsky and his relationship with her and how he misses her and the companionship that she provided for him and their connection to one another. I don't think that Mr. Thone had much having family ties. It seemed like he was kind of estranged from his family. I know they talked to his sister, kind of seemed to indicate she didn't have much to do with him. Sounded like he didn't have a whole lot to do with his son, who lives in Washington, D.C. I think 5 years minimum or thereabouts. A further sentence, a longer sentence, you start thinking 6, 7, 8, 9 years. I think the concern that I have, Your Honor, relates to the progression of his Huntington's disease. This is from the Cleveland Clinic, which I guess is a research hospital. This is from their website. How does Huntington's disease progress? Huntington's disease is a progressive condition. This means it slowly gets worse over time. The way the condition progresses varies for each person. It may include, at the early stage, symptoms are mild. You might feel moody or clumsy and struggle with complex thinking. You may also have small, uncontrollable movements. Typically, you can continue your everyday activities. I think that this probably describes Mr. Thone's Huntington's disease, at least the recent period. However, in the middle stages, according to Cleveland Clinic, physical and mental changes make working, driving, and household chores very difficult. You may have trouble swallowing, which can make speaking and eating meals challenging but not impossible. Balance may be off, increasing your risk of falling. You can still manage your personal care like bathing and getting dressed. And I wonder if he hasn't slipped into that middle stage at this point. I think just some additional difficulties, Your Honor, in understanding Mr. Thone. His gait is not exactly the same as it used to be. And I think he may be entering that middle stage. And then at the end stage, according to Cleveland Clinic, completing daily tasks is hard to do on your own. Most people aren't able to get out of bed without help. You'll need around-the-clock care during the stage, especially to eat, bathe, and monitor your health and well-being. So, I'm a little concerned if you're talking about a lengthy prison sentence that he's probably beginning to slip into the middle stage, and how much longer would it be until he's in that end stage situation where he's needing help even to get out of bed. Also from the Cleveland Clinic, what is the life expectancy for Huntington's disease? The average lifespan after Huntington's disease diagnosis is 10 to 30 years. So there's a bit of a range there, Your Honor. Obviously, there's a big difference between 10 years and 30 years. But if we're thinking that symptoms probably cropped up around 2018, 10 years is 2028, I think that it probably is not in the court's in the interest of the system that Mr. Thone be, at Stanley or wherever he ends up, needing round-the-clock care. I don't think that's appropriate. So I think that mitigates towards a sentence closer to 5 years than closer to either the 7.5 or the 9 or 10 that's recommended. So we would suggest a period of initial confinement of 3 to 5 years range, somewhere in there, with extended supervision of 5 years.
Thank you, Mr. Nelson. Mr. Thone, I'm now going to turn to you. If you wish to make a statement in court here today.
I'm sorry for everything that's happened. I'm ready to do the punishment. I'm ready to for it. That's it.
Mr. Thone, you have been in court before and you've had a couple convictions that are on your record. You don't have a very extensive criminal history. You have the disorderly conduct and the resisting or obstructing an officer, that the Douglas County case. You have an OWI second from Eau Claire County in 18 CT 94. You have Trumpereau County with your OWI first. You have that Bighorn County matter that was extremely similar to this case, except for the fact that you both were only injured and no one died. If I'm going too fast, please let your attorney know so I can slow down, so that I know that you understand everything, okay?
I don't understand what you said at the video.
Thank you. So, when a court sentences an individual, I must first look at the nature and the gravity of the offense. How serious is this matter? Then I have to look at your character, your past criminal record, needs for rehabilitation, those types of things, take into account your Huntington's disease, as well as your education, all factors related to you. The third thing that a court must look at is needing to protect the public. And that means protecting the victim and the victim's family, as well as protecting the community as a whole. I've heard the arguments of both of the attorneys. I've heard your statement. I've heard 3 victim impacts statements and how this loss has completely traumatized this family. I don't necessarily want to say destroyed the family. Hopefully it has been something to bring the family closer together. But it is a loss that is immeasurable. They will never get to see Jennifer again. The grandkids will never get to have that close relationship with her and have grandma come to their concerts at school or sports and activities, those types of things. It's a tremendous loss. You did accept responsibility by pleading guilty. You saved the family from even more trauma and more pain going through a trial. That's a positive. I say this a lot, and I really wish that it could happen. If I had a magic wand, I would change everything that happened, bring Jennifer back, and make everything good as gold. I'm sure you have the very same wish. Fortunately, This is reality, and we can't do that. We are here where we are here today, all because of what happened on, I believe it was August 17th, 2024. It was preventable. That was definitely 100% preventable. You have the history of drinking alcohol to an intoxicated level, and operating a motor vehicle. This would be. You should have known that. You should have known that, especially considering 4 months before, and I believe that was April 27th, 2024. 4 months prior to this accident, this unnecessary accident to occur, you did the very same thing, but in a different county. You drank to excess, you drank to intoxication, you drove a UTV, you rolled and crashed that UTV. Both you and Jennifer Kopinsky were hurt and injured, and you were charged with charges that, for whatever reason, was not a crime, simply a forfeiture. Okay. But it was the same actions, same conduct, same behavior, same thinking. Especially considering the diagnosis in 2020 with your doctor, Huntington's disease. I'm not positive. I was not in the doctor's office with you. I didn't receive your medical documentation and recommendations from your doctor. But I've had multiple people in front of the court with Huntington's disease. So I know a bit about it, and I've learned a bit more now about it from your attorney's argument, which was very insightful. But I'm going to guess, and I'm pretty sure I'm right, that when you were diagnosed with and confirmed that you have Huntington's disease, your doctor told you, do not drink alcohol. Probably not simply, you shouldn't drink alcohol because X, Y, Z. I'm going to guess your doctor said you cannot drink alcohol, because I know alcohol speeds up Huntington's, the use of alcohol, and especially on the medications that you need to take with it. There's no doubt in my mind you loved Jennifer. There's no doubt in my mind. So did everybody here. You have to live with the loss of Jennifer. Family has to live with the loss of Jennifer, but they're completely different. Your actions caused those. Your symptoms are extremely severe. You should not have been driving or contemplating driving at all, unless it's an emergency, and definitely not if you were under the influence. And with the who cares attitude, we only live once attitude, YOLO, it may be okay for you to have that attitude. It may be okay for you to put your life at risk. If you put so many people's lives at risk that day, and every other day you drove intoxicated, whether in a vehicle, whether a UTV, whether an ATV, you put a lot of lives at risk. And a who cares attitude, and we only live once attitude, killed Jennifer. And in a case like this, as your attorney stated on the record, that there is a mandatory minimum of 5 years of incarceration, unless the court finds a compelling reason and states it on the record that it should be less than 5 years. So I understand you have Huntington's disease, although I understand that it's an extremely serious condition and disorder, and that you're going to have a punishment. And even though I now understand a little bit more about Huntington's disease, and that you are in the middle stage and maybe in the end stage soon, and that could require continuous care and unable to get out of bed and an early death. I was aware of that possibility. I cannot find Huntington's disease in your position and where you are is a compelling reason to go below the mandatory 5-year minimum. I don't know how many deaths we've had in the last couple of years, but it's a lot. It's been a lot. For a small little county, it's been a lot. I love UTVs. I love going on the trails. And yes, sometimes it's nice to stop and have a drink or two.
This is the defining moment. The judge rejects the who cares mindset entirely. Risking your own life is one thing, but risking everyone else's crosses a legal and moral line. From here on out, mercy gives way to deterrence.